We have 5 cases on this morning. This is People versus Wafer. It is a 15-minute mini oral argument on the application. Ms. McCann, you can try and reserve some of that for rebuttal, but we let you try and control that. And if you are ready, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. Jacqueline McCann from the State Appellate Defender Office on behalf of Theodore Wafer. I will try to reserve 3 minutes of my time, and I'll try to keep track of that. Your Honors, this is, we have both arrived at the same place. I think that this is all about statutory construction. They get to it by a little different path than we do in their brief, but the whole ball game is statutory construction. The but without malice language in the statutory manslaughter statute is, it's brief, but it's very precise and clear that the legislature was importing the common law into the statutes. The murder statute and the statutory manslaughter were passed at the same time. The legislature was not repudiating the common law, they were importing it. There's no indication that they intended to turn the common law on its head and make manslaughter now not a mutually exclusive offense to murder, but some sort of additional offense and an aggravating sentencing factor for murder. So they remain mutually exclusive offenses, and these are not, just any offenses like some of the other statutes that have been cited for the but without language. This is murder and manslaughter, our most traditional offenses. If you compare the language in the statutes that I call the but without ex mens rea, which is a lot of the assaultive offenses, to the statutes where this court has allowed there to be multiple punishments, the causing death statutes, which are primarily in the motor vehicle code, whether it's driving on a suspended license causing death, leaving the scene of an accident causing death, drunk driving causing death. The statutory language difference is important. Those statutes don't contain the but without ex mens rea language that the assaultive offenses contain. They just contain the language causing death or resulting in death, indicating that the legislature is allowing double punishment there, whereas in the but without ex mens rea statutes, they are not.
Ms. McCann, let me interrupt you, and I'll start the questioning. And I agree with you. You and the prosecution end at the same place, relying on whatever the intent of the legislature was, which is how this court and the U.S. Supreme Court have defined this strand of double jeopardy. But I have to say, I was interested in the frame from the prosecutor that multiple punishment double jeopardy is really more properly considered a due process violation than a double jeopardy violation. It always feels a little counterintuitive to me that the way we try and figure out a constitutional limit is by what the legislature thinks about it, right? It feels not supernatural, that kind of analysis. And I don't want to take you too far off what I know is the part of your argument, but would you respond briefly to your thoughts about that?
I think what we as attorneys sometimes struggle to do is we know something's unfair and we struggle to find the right constitutional framework for it. I don't think there's any practical difference to whether we call it due process or double jeopardy. And I will say in the transcripts here at the actual trial, they did bring up the phrase due process, and they discussed all the concepts we are discussing just without necessarily naming them with case names or the constitutional language other than due process.
Thank you. Let me see who else has questions, and then you can return. Justice Zahra?
Not at this time, thanks.
Justice Viviano?
No questions, thank you.
Justice Bernstein?
Not at this time.
Justice Clement?
No questions, thank you.
Justice Cavanagh?
No questions for me.
Justice Welch?
No questions.
Mm-hmm. Okay, Ms. McCann, you may continue.
Thank you, Your Honors. I think I'll reserve the balance of my time.
That's the strategy, this case call. Okay, Ms. Smith, you may proceed.
Thank you, Madam Chief Justice, and may it please the court. Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, and we are the appellee in this matter. What are Mr. Wafer's rights in this case? He had a due process right to have the people prove his guilt on each element of each charged crime, and the people did so prove in this case. He had the right to have each conviction based upon sufficient evidence, which he has never contested. But Mr. Wafer does not have the right to face fewer charges than would be sufficient to account for all, not merely some, of his criminal conduct. Nor does he have the right to avoid the punishment authorized by the legislature for any resulting convictions. Pardon me. The charges in this case fully accounted for Mr. Wafer's actions on the night of November 2nd, 2013, when he grabbed a shotgun, opened a locked steel door at the front of his house, and immediately shot 19-year-old Renisha McBride in the face, killing her. Mr. Wafer initially told police twice that he did not know the gun was loaded and that it went off or just did so accidentally. Due to this evidence, the people charged Mr. Wafer with the crimes of second-degree murder and statutory manslaughter. It's undisputed that these crimes are composed of distinct legal elements. And thus, under People v. Ream, these are separate crimes, and it's presumed that Mr. Wafer may be properly charged, convicted, and punished for both. And while we're going to talk this morning about the specific language contained in MCL 750-317 and 750-329, and this court has never found that that sort of language is a clear directive from the legislature that precludes charging, convicting, and punishing under both statutes. Accordingly, Mr. Wafer's dual convictions do not offend double jeopardy or due process principles, and the application cannot be granted. I'll waive any remaining pre-fire I may have and stand for questions.
Thank you. So let me start with where I started with Ms. McCann. I found your briefing on the proper constitutional frame for this, for what we're talking about, compelling. I'm not sure it's something that this court could do given the U.S. Supreme Court and our precedent. Do you think we could write an opinion calling this kind of problem a due process problem and not a multiple punishment double jeopardy problem?
Absolutely. And I think that would be actually consistent with things this court has said previously and maybe has been less clear in other opinions. And I certainly don't fault the court for that. As I make clear in the next case we'll get to, Davis, the U.S. Supreme Court has really admitted that they've maybe been slightly imprecise when talking about what we're talking today, the multiple punishment strand of the double jeopardy clause. And I asked myself the antecedent question when we briefed in this case, does that actually exist? And I think that all of the exhaustive research I did shows that it really doesn't. And this court acknowledged that, and I think in People v. Wilson, that's from 2014, when this court said very plainly, the question of double jeopardy just is simply irrelevant in the context of a single prosecution because the defendant is in continuing jeopardy. And the other kind of, very, very basic part of that is, what does the Michigan Constitution and U.S. Constitution say about double jeopardy? It is singularly concerned with the commission of the same offense. But this case in Wafer and Davis, which we'll talk about next, the argument is that these are mutually exclusive offenses. So I just don't see how double jeopardy is the right framework. It really is due process if it's anything. But also, as Justice Rehnquist pointed out in some of his dissenting opinions, it can just be a matter of pure statutory construction. You don't even need to bring the Constitution into it. And that is actually significant because that precludes the U.S. Supreme Court from swooping in and telling the state court what is and isn't violative of their own statutory scheme. That's Missouri versus Hunter. So I hope that answers your question.
It does, but I guess my follow-up question is: does it matter? At the end of the day, I think Ms. McCann is right that this comes down to a question of legislative intent, regardless of what frame we put around it. Would you agree with that as well?
It's the same analysis, but I do think it's important just to be clear as to what framework we're working in. So if an opinion was to be written by this court, I think this court could clarify that under Hudson versus U.S., that SCOTUS case made clear that multiple punishments only exist in successive prosecutions. So double jeopardy really is not the right inquiry here. We're talking about due process. That is fundamentally the same as Mr. Boffin wrote in our brief. Two trains get to the same station, I should say. It's all about what the legislature intended.
Okay, thank you. Justice Zahra.
Thanks. You took us to the Ream-Blockberger test, but before we get there, we have to look at the statute. And it seems to me that in using the phrase, but without malice, the legislature has communicated that manslaughter is the backup charge if the people can't prove malice to obtain a murder conviction. And I think this is even, this is also supported by our case law. So if I conclude the legislature clearly indicated intent to prohibit multiple punishments with conflicting mens rea, we never get to the Ream-Blockberger test, correct?
I mean, that's debatable. A lot of the opinions in this case, they don't over rely on the Blockberger test as like the end all be all of statutory construction. It is a useful tool. You can use it first to decide to figure out whether the legislature wanted to allow multiple punishments, or you can look first to the statutory language and then use Blockberger if it's unclear. I know that's what this court said in Miller. And so I'm more than happy to get right into the heart of this case, which is what does that without malice language mean? And I think that is well laid out in our brief. We really have to keep in mind when the statutes were written. It's 1931, the enactment of the Model Penal Code. They just don't write statutory language this way any longer. The examples of that without malice or without intent language run throughout the penal code. And this court in Doss was very clear as to what it believed that language meant, and actually overruled People versus Chappell, which is an 1876 opinion from this court. They looked at the same language without malice and said that that type of language was integral to the statute's chief design, that you could not be convicted under that statute if the act was done with malice. This court completely overruled Chappell and Doss, 1979. So that's really the focus of the people's argument here, is this court has looked at the same statute in 1979 and basically made findings that are contrary to the position taken by the defense in this case.
Okay, I just want to make sure I understand it. Did you suggest early in your response to me that we have the choice to start with the statutory language or start with the Ream-Blockberger test to determine what legislative intent is?
So the U.S. Supreme Court will go either way on that. Sometimes they go straight to the Blockberger test. Then they look to see, is there anything in the legislative history that would rebut what Blockberger has told us, which is it's perhaps separate offenses. In Miller, this court said, start with the statutory language, then go to Blockberger. And so in Miller, you never got to Blockberger. I'm happy to talk about both. I think that, as I said, regardless of Blockberger, you still look at the statutory language to see if there's clear intent from the legislature to allow or disallow multiple punishments.
All right. I can't recall the name of the case, but you cited a 78 case that said this court overruled a prior decision. But all those cases pre-Miller, how much are they still instructive? Shouldn't we really be guided by Miller?
Well, Miller is a double jeopardy case. This is not a double jeopardy case, but it's still an instructive case as far as looking at legislative intent and trying to figure out if multiple punishments are permitted, which is what we're talking about as far as due process is concerned. Doss, I think, is helpful. That's the 1979 case I mentioned because it specifically looked at the statute we're discussing today, 750-329, and tried to figure out what that without malice language means. And that is the entire crux of this conversation.
Thank you.
Justice Viviano.
No questions.
Justice Bernstein.
I don't have any questions at this point.
Justice Clement.
No questions.
Justice Cavanagh.
No questions.
Justice Welch.
No questions.
You may continue, counsel.
Thank you. So I would direct this court to Doss, which defense is not asking this court to overrule. I know that the defense tries to distinguish Doss, saying Doss isn't a double jeopardy case, so really it doesn't apply here. But in my view, it does apply because it answered the fundamental question that we're struggling with here. What does without malice mean? In Chappell, 1876, when this court looked at that question, it said that without malice was fundamental to that crime's commission, and you could not convict a defendant if the defendant acted with malice. This court overturned that reasoning in 1979, and that decision has not been undermined by any subsequent decision by this court. So I think DOS does control, and it helps answer the question before the court, which is, what does that language mean? And how did the legislature use it in 1931, which is really the main inquiry that we have here. And even if it's, let's say hypothetically, let's say it's true that the legislature meant to say this crime could only be committed if the defendant acted without malice. Well, we should go to the original statutory penal code in 1931, which, Justice Bernstein, I'm holding up a book, the Michigan Public Acts of 1931, which we had in our office. I went through it yesterday, coming up to speed on this case.
Thank you so much for doing that. That is incredible. Like, thank you for that. It's just that was very considerate, and I want you to know I really appreciate you doing that.
Oh, you're welcome. I just thought it was funny. I'm bringing a demonstrative with me today. Because I think that, in Miller, this court, it's a little bit different. Miller was a statutory analysis that concerned itself with one chapter of the penal code. I think it was 257-625. Here we're talking about many different sections under one umbrella, the homicide section. So I went to the book and pulled it up, and it begins with 760-316, which is first-degree murder, and ends with statutory manslaughter, the crime we're talking about today. But what I thought was really interesting is that 750-324 is negligent homicide, and it describes a mental state that is exactly consistent with the idea of manslaughter. Specifically, that crime required that an act be done carelessly, recklessly, or negligently, but not willfully or wantonly. That is malice. That's describing acts that are done without malice. So this, in my view, shows that if the legislature actually intended this statutory manslaughter, 750-329, to be committed without malice, this other section, 324, shows they knew how to say that. But that is not the language that they use. They use this, for the modern eye, a little bit unusual way of describing it, acts done without malice. This court has said that means that the people need not prove the act was committed with malice, and that it just shows what we need not prove. And that's important when we talk about all the assaultive statutes, because there's a lot of repetitive or a lot of language of that nature in that statutory scheme as well. So that's just something I wanted to bring to the court's attention, because it's addressed in our brief, but maybe not quite with that level of specificity. The other issue I think that's interesting to think about, defense is asking that DOS not be overturned. DOS means what it says. DOS was in a double jeopardy case, but somehow what DOS said, which is that this language doesn't require the act to be done without malice, somehow that changes if the inquiry is due process or double jeopardy. Two statutes, when paired up together, seem to conflict. I don't see how in one sense, the language is inert, and the other, it springs to life and somehow has this forceful effect of disallowing cumulative punishments. And again, I can find no case with similar language where this court has said this is a clear expression by the legislature to disallow multiple punishments. So that's really the heart of the people's argument, and I'm certainly happy to answer any other questions. Otherwise, I think I would just rest on the brief that we filed.
Thank you. Are there additional questions for Ms. Smith? Thank you very much. Ms. McCann, you reserved some time.
Thank you, Your Honor. I did want to talk about DOS, and maybe I should have pushed back harder against DOS, because when you look at the premise of it, why does the Supreme Court get to tell the legislature what elements it can or cannot put in a statute, as long as they're not, committing some constitutional violation? When I look at that case again, it almost seems like the opposite side of the coin of strict liability offenses. Courts don't like it necessarily when when the legislature makes strict liability offenses and makes them jump through some extra hoops to make it clear that's what they're doing, but the court can't forbid them from doing it. So I don't see how the court could forbid the legislature from making a negative element if it wanted to. But you don't need to overrule DOS, because DOS just needs to be cabined to what it was. If you think about what this court faced when it decided DOS, it was a single charge, and the defendant was essentially saying, look, I'm guilty of the higher offense. You can't convict me of the lesser offense. And that was true in Holstag too. And in those circumstances, the court said, no, you've at least committed manslaughter, essentially. And at that time, had the defendant in that case been charged with murder and manslaughter and been convicted of both somehow at trial, at that time, double jeopardy would have absolutely precluded that. And that's why the court didn't address double jeopardy in Doss, because there wouldn't have been an issue of it. And it was, pre-Cornell. And at that time, it would not have gone to the jury as an extra count or an additional count. It would have been clear to the jury that manslaughter was a lesser included offense of murder. And that's why Doss doesn't make a difference, because it's not really applicable to what we're talking about today. And it's not just that the statutory language, but without malice, is, if you wanted to put it in sort of a Blockberger terminology, that means murder has a different element than manslaughter. Well, yes, it has a different element, but it's not just a different element. It's a mutually exclusive provision that they are not to be, that you cannot commit an act both with malice and without malice at the same time, which this court even acknowledged in Doss. The people talk about in their brief and a little bit today that it's just a designation, that it's just sort of a definitional thing. Well, why would the legislature need to make a distinction or some definitional statement if it made no difference to them? If they didn't mean it to have any effect, that just doesn't make any sense. If you read the statute 329 without reading the language but without malice, that's how we're applying it today, as if that language isn't there. And in Miller, this court relied on the statutory, the rule of statutory construction, that you can't render language surplusage or nugatory. And again, this isn't just any old offense that's new on the books. Murder and manslaughter have been around forever. The legislature imported that common law into these statutes, and there's no indication that they meant to suddenly convert manslaughter into an aggravating additional offense, as opposed to keeping it as a mutually exclusive offense to murder. It just, the other day, a few weeks ago, the court was having its public hearing, and you were talking about the truth-seeking function and whether fictional pleas or equitable pleas, whatever you want to call them, serve the truth-seeking function. Well, this is a trial. It doesn't serve the truth-seeking function to hide the statutory language from the jury when the defendant is charged with both murder and manslaughter. That's not the truth-seeking function, to convert it into an additional offense or an aggravator, when that is not what the statutory language indicates. So we would ask this court to strike the manslaughter and remand for resentencing.
Are there additional questions for Ms. McCann? Okay, thank you both. This case will be submitted.